Everybody. Welcome. Happy Saturday. And welcome to our 2 hour trial wrap up. For those of you who caught our surprise live, there's not a lot to update you on between now and then, but we have plenty to talk about, plenty of questions to take. So I thought I would just start out by telling you a little bit about how the week has gone for trial. For those of you who can see back over my head, that little line of those papers hanging from the wall is the first week tickets to get into the courtroom. Every day we have to go online at 8 a.m. and put our name in for the next day's tickets. I have been very fortunate that my dear husband has taken it on, made it his job. Hang on here, I'm going to center myself a little more, to put me in every morning for those tickets. And thankfully, he's been pretty successful. So the very first day that the courtroom itself will be open is Monday, and I have a ticket for the courtroom. So let me just sort of explain the setup because I think that'll help everybody sort of get a better picture. Ada County Courthouse is a good-sized courthouse and fairly new. And the fourth floor is where Lori's trial is happening in courtroom 400. That floor is primarily dedicated to civil and family matters. So there's a couple little quirks for that courtroom or that area that make it maybe not the most ideal place for a criminal trial. And one really important reason that it's the perfect place for a criminal trial, and that's it's the biggest courtroom in the courthouse. So the courtroom itself holds about 75 people, which is a pretty good sized courtroom. They have one section set aside for witnesses and family members. So there are 60 spaces available for media and the public. This case is unusual in that the courthouse has not designated media. They haven't issued media credentials. They have not set aside a specific area for the media or given them any special access. So all of us, Justin Lum, Nate Eaton, all of the online creators, local news here in the Boise area, any national news organizations, News Nation, Law and Crime, they are all having to go through this same exercise of every day at 8 o'clock going and putting their name on in the reservation hopper. Friday morning, excuse me, Friday morning, when we knew that Monday was going to be opening statements and the first day of testimony, those tickets in the courtroom went in 2 minutes. By 2 minutes after 8, all 60 of those spaces were gone. According to Justin Lum and Nate Eaton got number 1, Justin got number 4, I got number 20. So I'm happy with that. It means that we're all going to be in the courtroom. So the way it's set up is on the first floor is the county commissioner's office or chambers. And it's a large room with a commissioner's dais at the head of the room and then about 200 chairs. So there are about 200 spaces in the overflow space. Last week, we had between 20 and 40 at any given time. Now, the overflow space, there was a big video movie screen that came out of the ceiling, and the stream from the courtroom was projected onto that movie stream. They've been trying to perfect the camera angles for a while and the location of all the seating. It started out that they had the prosecution face on, they had the defense table perpendicular to it, and the defense table was set up in front of a window, which meant that didn't get much video feed that wasn't completely washed out by the light. So we were really just seeing silhouettes. Initially, they had 3 cameras. They had one trained on the judge and one on each of the benches, the prosecution and defense. By the second day, they had moved things, or the third day, I guess, they had moved things around, adjusted the cameras so that we have prosecution and defense both facing the same way, the judge facing out so that you can see prosecution, defense, and the judge behind them. So the jury is to be kept private, as it was in Murdoch, if you watched that one. The cameras in the courtroom are turned so that no one can see the jury. On the feed, certainly if you have a seat in the courtroom, you'll be able to see the jurors. So for the last week, while they were working on picking a jury, everyone was in that overflow room. The main courtroom was not open because there were times when they cut off the audio feed while they were asking questions of prospective jurors. Primarily, those questions had to do with personal matters or matters that would impact on their privacy. So we perked along the first day at a pretty good clip, kind of bogged down on Tuesday. Wednesday felt like we didn't make a whole lot of progress. There were a lot of jurors that were excused for bias in those groups. Thursday, we got almost to the end. So what the judge had said was he wanted a pool of 42 jurors that would be the pool from which the final jury would be picked. So all of those jurors had to be qualified and passed for cause, meaning that each side had said there wasn't a cause to excuse them, particularly for bias. So we got to 39 on Wednesday night. Thursday morning, they were finally able to get the remaining 3 jurors and seat the jurors. And we came back on Friday for peremptory challenges. Now, peremptory challenges are those challenges that are made by each side, and each side has so many challenges where they do not have to give a reason. They only have to say that they're striking that juror. There are some Supreme Court rulings that say that you cannot you can't strike a juror strictly for their gender, their age, or their religious preference. Now, if there are or their race, sorry. If there are other reasons to strike that juror, you have to be able to articulate those if the court asks. It's allergy season here, and yes, this is me medicated. So finally, Friday morning, they brought the final jury in and they did the peremptory challenges. Peremptory challenges, some of the people in the room didn't even realize they were going on, because what happens is each side is given, in this case, let me do the math before I tell you about peremptory challenges. So the judge said, I want to finish with a jury of 12 and 6 alternates. Now, if you remember in the Murdoch case, they got down to their final alternate before the jury deliberated. In the Murdoch case, the jury didn't know, but the lawyers and the judge knew who the main jury was and who the alternates were. In this case, Judge Boyce has said that he is not going to determine who will be the panel and who will be the alternates until it's time to deliberate, and then they'll do that by drawing lots. That's to keep the jurors interested and attentive because we don't want jurors who think, oh, well, I'm the sixth alternate, so the likelihood I'm going to end up deliberating is going to be maybe small. And so I won't pay as close attention. So we want to be sure that all of our jurors are engaged and paying close attention to the case. So the judge said he was giving each one of the lawyers 12 peremptory challenges. It's typical to have 10, but he did have the authority to give them each 2 more and did. So there were going to be 12 peremptory challenges. He was going to end up with a panel of 12 jurors and 6 alternates. So that math adds up to 42. So we needed a pool of 42. When that happened, then the peremptory challenges started, and they were able to, everybody had a list of the jurors and had gone through and made their notes and determined which jurors they wanted to strike. And then everyone got 12 little pieces of paper. And on those pieces of paper, they wrote a juror number of the juror they wanted to strike. They would then provide that to the other side, who would mark it off their list, and it would go to the judge. And they did so. The prosecution struck one, the defense struck one, and they go back and forth until they are completely finished. And so at the end, the judge had 24 jurors that had been struck by one or the other of the attorneys. And the process works so that no one really knows who struck which juror once the whole process is done. So then the judge called off the numbers of the jurors that had been struck, and they were excused. And then they ended up with that jury of 12 and the 6 alternates. The judge gave a few instructions, and mostly not to talk about the case, not to research the case, not to do any independent research on it, and to not do anything risky like go skydiving or chainsaw juggling was the other thing he said. So it was a little moment of levity in the case, and then everyone was dismissed early on Friday. Now, it is the Friday before Easter, or was the Friday before Easter, and I think the judge felt like people wanted to go back to Rexburg. Those folks who are involved in the case directly wanted to get back to Rexburg for the Easter weekend. So I expect that tomorrow afternoon there's going to be a caravan back from Rexburg for trial on Monday morning. The judge has said opening arguments will begin at 8:30 on Monday morning, and the courthouse opens at 8. So yours truly, your girl, as Gigi says, will be there at 8 o'clock, and we'll be ready to get started. And I'm really interested to hear what the lawyers are going to say. So let's just talk a little bit about court procedure, trial procedure, because if you haven't been watching trials for a while, some of this won't seem all that familiar. So let's talk a little bit about that. The first thing that happens is that the judge is going to swear in the jury. What that means is he is going to give the jury an oath of office, that they are going to take an oath, that they are promising to decide the case fairly, to not do any independent research, to avoid media. He's going to ask them to take an oath as to what they'll do and what they won't do. And once that's done, then he will give them some basic instructions about what happens next. And after that, in those instructions, then they'll probably take a short break, and they will come back, and the judge will say to the prosecution, opening statements, please. We don't know who is going to give the opening statement. We don't know of the 3 attorneys who will be doing that. And we don't know who will be giving the opening for the defense because they have two attorneys. So um, we'll wait to see who's going to provide that opening statement. Now, opening statements are very different from closing arguments, and they're called different things for a reason. An opening statement is a way to explain the case and give a bit of a roadmap of where the case goes to the jury. It's not always possible, and it's not always really desirable for an attorney to put a case on in chronological order. So the opening statement is in many ways a roadmap, a timeline that gives the jurors some hooks to hang things on when that piece of information comes up. So, for instance, um, they may chronologically, that for a variety of reasons, they may decide to put on the FBI agents who were there and who processed the scene when the children's bodies were found. Well, that's far from the beginning of the story. But the opening statement, in the opening statement, you're able to give them sort of that roadmap and say, okay, that piece goes here in the timeline. We're the timeline starts here, but this piece of evidence belongs further down the timeline. So that's the way that opening statements should be used. Occasionally, you will hear one side or the other object to opening statement information because it is moving over into the realm of argument. An argument is not appropriate for opening statement. That's for closing. So once the opening statements are are done, then we get for the prosecution gets to call their first witness. Now, one other thing to keep in mind when we're talking about opening statements, the defense can reserve their opening statement and give their opening statement before they start their part of the case. There's a lot of opinions out there about how wise it is to do that. I happen to think opening statements should be given right away because you don't want the only voice that the jury hears to be the prosecution's voice, and you don't want the only thing they hear to be the prosecution's story. By the time the defense gets to give their opening before their evidence, many of the jurors already have a fairly clear picture of where the evidence has gone and perhaps have already made up their minds. So it's important for the jury to be able to hear the defense's voice in that early process. So then the prosecution begins to call their witnesses, and they usually begin with the foundational witnesses, which are going to be the very technical witnesses. We saw this in Murdoch. We saw a lot of witnesses having to do with digital data and DNA data and fingerprint and footprint and tire tread data, shoe data. All of those things really came up at the beginning because for two reasons. One, you want to get that out of the way for the jury so that they can really then start to think about the more personal aspects of the case, the things that aren't quite so technical. But you also want to lay that foundation so that there's no question about that evidence coming in. And that means that you're bringing in a lot of custodians of records and people who collected the DNA and people who processed the DNA. Those who watched Murdoch, I'm sure the first day or two, your eyes were ready to cross because there was so much of that technical information and very laboriously coming up with, very painstakingly laying that foundation. So that's the thing that will happen early. And then I think we are going to get to the witnesses who everybody is very interested to hear from. We're going to get to Kay and Larry and other family members that have been called to testify about the disappearance of the children and what they were thinking as they were frantically looking for the kids. We're going to hear from the landlord in Hawaii. We're going to hear from the FBI when they tracked all of her travel and movements. So there's a lot of data that's going to be presented. One of the key pieces of data is going to be the digital information. We know that they have terabytes of information, a lot of which is very likely digital information. So be on the lookout for that, and don't discount it because it's boring, detailed minutia, because the digital evidence in this case, I think, is going to be as critical as it was in the Murdaugh case. And if you recall, they really got granular with it. They were looking at how many steps people took and where they were taking their steps. And so I think we're going to see a lot of similar information coming out in the Daybell case. One of the things that the prosecution asked the jury was, could you convict if you did not know the cause of death? If you did not know the actual mechanism of death? Now, we have 3 murders. Tammy's murder was, her body was exhumed and autopsied, and we have heard, although we haven't seen any definitive evidence, we have heard that her cause of death was attributed to asphyxiation. Asphyxiation can mean everything, can mean a lot of things. It can mean strangulation. It can also mean smothering. It can mean any mechanism that interrupts someone's breathing. I think because of the state of JJ's remains, it's likely they'll be able to at least preliminarily describe his cause of death. But I suspect it's going to be much more difficult for Tylee because of the condition of her body. Her body was dismembered and the parts were burned. So I suspect that it is Tylee who they cannot definitively identify a cause of death. An interesting thing to note is that late on, well, in the morning on Friday, while we were talking to one of the court administrators, about the setup for the overflow room, the setup for the courtroom, she said to people, please be aware that unlike the Murdaugh case, where they turned the screens around so that only the jury could see the evidence, the audience will be able to see the exhibits and the evidence, and there are going to be difficult images. So I think that gave a few people pause. I hope it did. I hope they've thought through it. Those are difficult. I'm here to tell you, I've seen a lot of those photos, and they are always difficult. One of my first training seminars when I joined the district attorney's office was a multidisciplinary conference on domestic violence. And ahead of that conference, I was sent to a 2-day conference on prosecuting child murders. And that seminar opened with 200 autopsy photos. That's hard. So I'm just cautioning the people in the general public who might be wanting to attend the trial. Those are tough images and they can't be unseen. And you have to go into it with a personal, maybe internal strategy for how you personally will cope with that and how you personally will find ways to decompress from those because it's very difficult. 525 people in chat. Welcome. Thanks for joining us today. And so what will go on in the courtroom is that the prosecution will call all of their witnesses. They will offer all of their evidence, whether it's in the form of text messages, phone calls, phone records, GPS data, you name it. They will offer all of those exhibits and all of that testimony of witnesses, and then they will rest. Now, somebody asked me whether or not the prosecution would be bringing in Charles Vallow's murder, and I don't believe they will. If you recall in the Murdoch case, there was a whole off the record, out of the hearing of the jury, 2-day long taking of testimony and discussion about prior bad acts that have been committed by Alec Murdoch. And in that case, Judge Newman ruled that that information could come in because it went to describing what may have been the motive for Alec Murdoch murdering his wife and son. I don't think you have that here. So I am not expecting that the prosecution is going to try and bring in the murder of Charles Vallow. It may come in sort of tangentially if the defense's intention, their theory of the case is to blame Alex. So we don't know yet. We're just going to have to wait and try and see what happens in that regard. Once the prosecution rests, then they will, the defense will move for what's called a directed verdict. And it happens in every case. If not to do it is considered malpractice and ineffective assistance of counsel. So what it means is that Jim Archibald and John Thomas will say to the judge, "Judge, we do not believe that the state has proved their case beyond a reasonable doubt. And so we're going to ask the court to dismiss this case out of hand as not having been proven. We're going to ask for a verdict in Lori Vallow's behalf, in her favor." Now, these are hard motions to sustain because the rule also says that the judge has to construe any questionable evidence in favor of the prosecution. So they typically do not result in a verdict, a verdict for the plaintiff, the defendant. Sorry. And it's a rare occurrence where a judge gives a directed verdict. That's why it's such a there's always a big hullabaloo when it happens. So then the defense will come behind. Now remember, the defense does not have to put on a single witness. They don't have to disprove the prosecution's case. The prosecution has to prove their case beyond a reasonable doubt. So, but it's likely that they will put on some witnesses. Now the question is, does Lori Vallow testify? Now, I have a bet that she doesn't. With Zara, I got to think about it for a minute. there's a pound of coffee riding on it because she thinks Lori Vallow will take the stand. I think Lori's going to follow the advice of her lawyers and not take the stand. But a lot of people do think that she is narcissistic, maybe enough, as Alec Murdaugh was, that she'll want to take the stand, even though it's not really in her best interest. So she may or may not take the stand. The defense will offer their evidence and their witnesses in support of Lori. We expect that their theory of the case is going to be it was all Alex Cox's fault, and so he's the one that should be blamed, and she should be found to be blameless. She did offer an alibi, but that's a little silly considering that the charges are for conspiracy, and conspiracy, you can conspire to commit a crime that you're nowhere in the neighborhood when the crime happens. So once that happens, then the players, the both attorneys will be allowed to give closing arguments, and closing arguments are intended to be twofold. They really are the time when the lawyer gets to connect the evidence and the law and say, here's all the reasons why we proved our case. Or in the case of defense, here's all the reasons why the prosecution didn't prove their case. It's also a good way for both sides, really, to start to connect up the dots and make sure that in the minds of the jurors, they have made the appropriate connections between the evidence to link up what is clearly going to be a circumstantial case. We don't have any eyewitnesses. We don't have anybody who was privy to the crimes who is either living or willing to testify. So the case is circumstantial. And it's important in a circumstantial case for both sides to connect up. There's all of this whole line of circumstances to give the jury the confidence that they're finding guilt or innocence based on the facts. So once that has happened, then the judge will once again read jury instructions to the jury. So these jury instructions are going to include how to deliberate, the order to deliberate, the order that they'll deliberate on the charges. They'll be given instructions on how to conduct their deliberations, that somebody is supposed to be appointed as the foreperson, and they'll be given verdict forms. And the verdict forms essentially lay out all of the elements to the crime and then say, if you believe that Lori Vallow committed this crime, then check yes, check this box guilty, and sign. At the end, the jury will come back in. Once they have reached their verdict, the jury will come back in. The judge will look at their verdict forms and make sure that they're correct, that they've completed them in the way that they intended, and that they have reached the verdict they have intended. In Idaho, the jury has to be unanimous. So the judge very likely will ask then, the judge then will either read the verdict or will pass it to the bailiff and have the bailiff read it. Depends on the preference of the judge and the jurisdiction. Once the verdicts are read, then the judge is going to ask whether either one of the attorneys needs to have the jury polled. Meaning, do you want me to ask the jury if each juror individually, if this was their decision and their vote? And usually the jury is polled, and usually they go right from one end to the other and say, juror number one, is this your decision? Yes. Juror number 2, is this your decision? Yes. And they go all the way through the jury box. Once the verdict comes back and is read, then the judge will schedule sentencing. Now, according to Idaho law, the judge has to allow at least 2 days between the date of the conviction and between the verdict and sentencing. In reality, it takes a lot more time. Here's the reason. The judge is going to ask for a pre-sentence review, a pre-sentence evaluation, and any recommendations from the pre-sentencing body. This is not unlike a mitigation phase in a death penalty case. It is less in depth and certainly not decided by the jury. It's decided by the judge, but the judge asks that a pre-sentence report be created, that be accomplished, and then provided to the court and all the parties so everyone knows what sentencing recommendations are being made. Now, the judge doesn't have to follow those sentencing recommendations. The judge doesn't even have to follow the recommendations of the DA. The judge is free to impose a sentence that meets Idaho law, regardless of what any of the either side asks for. So, got to take a sip here. Once the pre-sentence report is done, then the judge will complete sentencing. Pre-sentence reports can take up to a couple months. So it's likely that if there is a verdict in late May or early June, we wouldn't see her actually sentenced until maybe July or August. More like August or September. In the meantime, it's doubtful that Ada County is going to want to hang on to her, and doubtful that she is going to want to stay in Ada County. So I suspect that they will transfer her back to Madison County, where she will await sentencing. It's possible she could be sentenced in Fremont County rather than having to come back to Ada County, because the judge and all of the lawyers are all there. So then the next thing that happens is each side has 30 days in which to file a notice of appeal. Now, from the state standpoint, their ability to appeal rulings is very limited, but there are some instances where they can appeal. The biggest thing, the biggest appeal will be on the part of the defense. So the defense is going to raise every issue that they believe is colorable, is potential. They're going to raise every one of those issues in an appeal. So the notice of appeal is filed. The appellate court comes back and says, okay, we got your notice. You have until this date to file your opening brief, usually 30 days. And so the other side gets to work on it. What many times delays an appeal is you file your notice of appeal, and one of the things that you need is a written transcript of the trial. Well, if you have a 6-week or 8-week trial, it is going to take 3 times that long to produce a written transcript of 3 weeks of trial. So it could very well be months before that is created, and she can actually file her appeal, her notice of appeal. In the meantime, Chad Daybell's trial is going to come up. His new trial has not been scheduled yet, And it doesn't surprise me that they will wait until after Lori's trial to reschedule his. Sometimes, maybe even a substantial amount of time, when one co-defendant is able to sit back and see the evidence against the other co-defendant, it causes them to take a plea offer. So it is possible that he could plead out once he sees how the case comes together for Lori. And remember, he is still facing the death penalty, although she is not. So if he is concerned about receiving the death penalty, it would make sense for him to take a plea. Hard to tell until we know for sure how the trial is going, but it's always a possibility. So I think that's about it for what to expect coming up. And that's about it for what happened last week. Now we're going to get into some in-depth and juicy stuff next week once testimony starts. At least we hope it'll be juicy and it won't all be dry DNA analysis and GPS coordinates. So let's take some of your questions. And we can chat about that. While our mods are pulling up questions, I want to bring up something else. Social media has been a blessing and a curse to true crime in many ways. If you think about some of the great discoveries and disclosures that have happened thanks to our true crime community and the investigative work they do, it would be easy to say, oh, it's much better to have this true crime community. But there is sort of a danger, and the danger is that we jump to conclusions, and the danger is that we retransmit information that may be not reliable. So I've had a couple of people ask me, and I want to be very clear about this. This has to do with the Brian Kohberger case. Kohberger's car was searched. It was seized and searched while he was still back in Pennsylvania being extradited. They did an inventory. They also searched his parents' home, and there were search warrant inventories done. Every time some piece of potential evidence is seized by the government, it has to go on an inventory list. And so there were the handwriting of the person who was doing the collection of the evidence was pretty difficult to read, but it appears that there is an entry that says 4 IDs, perhaps number 4, but that's unclear, IDs in a glove in a box, and reportedly found inside the home. There is a group who have jumped to the conclusion that these are trophies and that they are IDs that belong to the victims. It is possible that that's the case, but it is also possible that those IDs could have a very innocuous reason for existing. And I'm deeply concerned about people who are retransmitting this, and in some regards, some of the major news organizations retransmitting this when it is unverified information. We know that they found IDs in a glove in a box, but to jump to the conclusion that because of that, they must be and because there were 4 of them, they must be the belongings of the victims is really irresponsible. So I just want to encourage you all, because I think we have a true crime community that's a cut above. I think we have a remarkable community. You are remarkably patient with one another. You are remarkably educated about the case and about the law. And so I think as that in our group, it's unlikely that you all are jumping to that conclusion, but in case, because it's juicy. I mean, let's face it, if those kids' IDs are in his pocket, he's sunk, and it is a smoking gun. But we don't know whether it's those what they've found is even remotely related to the murders. So we have this rampant speculation going on, including from some fairly influential talking heads in the media. And I'm just suggesting to everyone, before you jump to that conclusion and hop on that bandwagon, step back a little bit and think about how much we really know. Kathy Bethel, this is a really good question. I had it come up earlier, and I'm glad you brought it up again, because now I have the opportunity to talk about it when y'all are when we can talk about it together and not just in a single comment in a YouTube comment. Her question was why in the Letitia Stout case, the jury is able to ask questions. This is something that varies from state to state, and in some states, juries are allowed to ask questions. In federal court, jurors are allowed to ask questions. So what happens is, at the end of a witness's testimony, before the witness is released, the judge asks the jury, "Do y'all have any questions?" And then the jurors write on a piece of paper their question and send it to the judge. Now, not all questions are going to be answered, because not all of them are admissible under the rules of evidence. So sometimes juries want to know the answer to questions that aren't really relevant or aren't admissible under state law. So the judge acts as the gatekeeper. He goes through all of those and decides which ones to ask and which ones not. He shares those with the defense and the prosecution beforehand to make sure they don't have any objections, and then they ask the questions. In some regards, it seems pretty helpful. In others, I think that it can lead to the jury hearing, or at least formulating, a question that gives them information about the case that may not be admissible. So it is a little more difficult for judges to be able to control the courtroom and control the proceeding if they've got this sort of unknown group who are posing questions. So in Idaho, juror questioning is not allowed, but in Colorado, where Letitia Stout is being tried, it is. Good questions, guys. See, this is what I love about our groups. Y'all are so thoughtful, and it's so clear that you have that you have learned new things as we've walked through this case together, and that you're using that knowledge to be better informed citizens. So good job, guys. I commend you for that. Hi, compassionate RN. In the Murdaugh case, Judge Newman sentenced Alex right away. Why would it take so long for Lori to be sentenced? In the Murdaugh case, they did not do a pre-sentence report. They didn't do a pre-sentence evaluation. And again, this is something that varies between states. So in Idaho, the judge must allow at least 2 days after the verdict before she can be sentenced. But in practice, it takes much longer because of this pre-sentencing evaluation that needs to be done. And the pre-sentencing evaluation not only is going to speak to the length of her sentence, but also is going to speak to what sort of a candidate she is for any sort of programs while she's in the prison or any kind of education projects, any of those things. So, pre-sentence evaluation is not required in every state, but it is in Idaho, so that's the reason for the difference. Thank you so much, Debbie. Thank you from our moderators. While we're having this little lull, we have 684 people in chat. If you have not yet subscribed, please pop out, subscribe, hit the bell so that you get notifications. And while you're out there, hit that like button. Hitting the like button is going to help us out with our algorithm, but going out and subscribing and asking to have notifications activated is going to help you out, because I am posting YouTube shorts or short videos on as many platforms as I can daily from the courthouse. I'm doing that as I have the opportunity during the day. So you're not going to know about when those shorts drop. Oh my. When we post those shorts, I'm not going to be dropping my shorts. It's been a long week. I'm getting a little punchy. I'm going to be posting those shorts when I have the opportunity, and you probably won't get a notice that they're coming. It'll just pop up. So if you are subscribed and get notifications, you'll be notified when those short videos post. So please do that. I also want to tell everybody, I've noticed there have been several very generous super chats. All of your donations through super chat, through PayPal, all go directly to our moderators, because I appreciate everything they do to keep our channel running, to keep our Facebook group running, and to keep everything moving along while you all are in the chat. Because if anybody's ever seen one of my videos where I've had to moderate my own show, it's painful. You don't want to see it. So I think, please, if you get the opportunity to leave a gift for our moderators, we appreciate it. It is not expected. This is not a membership show. Our content is free to the public. And I don't ever want anyone to feel put off by the fact that they're not able at this point to make a donation. We appreciate your presence is present enough for us. Gritty Gret, do you think a great deal of new shocking evidence will be presented during the trial? I think it is very possible that we're going to see some shocking new evidence. One of the reasons I think that is because, unlike Arizona, Idaho has an exception in their Freedom of Information Act rules for pretrial information. So they can say you can't have it until the trial is done. That means that all of the information that the state of Idaho has collected, pretty much they have not released. We have a few little tidbits. Some of it came through the releases from Arizona. Some of it was sort of alluded to. But I think that we're going to see a fair amount of new information that we haven't seen before. Shocking, I don't know, but I think we're going to see information that we haven't seen yet. High score. This is a good question. I was under the impression, now I want to remind everybody, I'm not an Idaho lawyer. I'm licensed in Arizona and in Oregon. And sentencing is very much a unique area of the law that is different in nearly every state. Some states have determinate sentencing, sometimes indeterminate. It's all very, very jurisdiction specific. I, in reading the statute, was under the impression that since the death penalty had been taken off the table, the judge could not sentence her to life without parole. I have been told that that is not true, that that is not correct, and that he, in fact, can sentence her to life without parole. And I have that on great authority from an expert in Idaho law, in Idaho criminal law. So until I hear otherwise and get it from the statute, I'm going to take her word for it and say, yes, life without parole is still a possibility. I I understand how she reached that conclusion and was very confident in it. So I expect that that is the case. 708 people in chat. Thank you so much for spending your Saturday night with me. I appreciate it more than you can imagine. The last week has been a blast. I have gotten to sit next to Gigi every day. I'm picking up my Southern drawl as we speak. And I've had the opportunity to meet some really interesting people. I met and having dinner on Monday night with Leah Sotili. She wrote the book When the Moon Turns to Blood. Leah's book and my book both are focused on the Daybell case, but from very different perspectives. So where I'm really focused on the case and what happened in the case, her focus is on religious and political extremism. And it wasn't until she heard that Lori's father, Barry Cox, was a Federalist and something of an extremist that she got interested in the case. Leah has been covering extremism, political and religious extremism in the West for years. She was deeply involved in covering the case of Ammon Bundy and the occupation of the Malheur Wildlife Refuge in Oregon. She is an Oregon resident and has been interested in these extremist groups that sometimes exist in Idaho and also in Washington and Oregon. The West Coast has sort of been a hotbed for those sorts of extremist views. So I thoroughly enjoyed getting to know her, really enjoyed my visit with her, heard her read from her book, and I'm looking forward to getting together with her on Monday. A couple of other things happened. I appeared on yesterday, Friday, the days are just like a blur, with Harvard lawyer Lee. She is a criminal lawyer from Georgia, and I appeared on her show last night. That was a blast. I was super excited to get to know her. And I'm going to be back on with her on Monday to talk about opening statements and the first bits of evidence coming in. Debbie Biggs, I'm going to answer this question. Why were they able to sentence Murdoch the next day? They technically could sentence Lori 2 days after, because the statute in Idaho says that there has to be 2 days in between the verdict and sentencing. There's a reason for that. The reason is because typically the state is required to notify victims of the crime, and they're not always in the courtroom all the time. So the state is required to have time to notify the victims so that they can come and give a victim impact statement. In the Murdoch case, the victims said they weren't interested in making impact statements, so that shortened the time period that the judge might have allowed additional time for. And the judge in that case did not order a pre-sentence evaluation. Some states do, some states don't. In Idaho, it is very typical for the judge to order a pre-sentence investigation. So that's the reason why he was sentenced so quickly and why it could take a couple months before Lori is sentenced. Good questions, y'all. You guys have been paying attention and doing your homework. Hi, Dawn. This is a good question, and I don't have an answer for it yet. Will they hold the FOIA requests for trial until Chad's trial is complete as well? I hope not either. I think so much of this information is going to come out at the trial that it would be sort of pointless to hold the information pending his trial. The FOIA law in Idaho does say that information pertaining to a pending trial is exempt, but if it's already been released in a prior trial, it doesn't seem to me like it should be embargoed until Chad's trial. Several people have asked me whether it's possible that a different judge could try Chad's case, or that it could be moved to a different venue, or that cameras could be allowed in the courtroom. So let me just take those all one by one. The only way a different judge would be appointed would be if Judge Boyce wasn't able to continue and do Chad's trial. When the change of venue was granted from Rexburg to Ada County, the statute says that the assigned judge can either come with the case to the receiving venue or can ask the court to appoint a new judge for the case. In this case, Judge Boyce has never wavered on continuing to be the judge on the case. Could they change venue? It's possible, but that would take a motion from Chad and his defense team. And where would they go? The justification for changing venue in the case initially was because of the level of community awareness and the level of publicity, local publicity in the case. I cannot see that publicity is going to get any less with Lori going to trial and after her trial. So the final question is, could he change his mind about cameras? He could. Please understand, in Idaho, it is very much a decision that rests with I'm sorry, I was catching something in chat. It is very much a decision that rests with the judge. There is no recourse. There is no appeal. The final decision rests with the trial judge. And so there's no way to go to the administrative judge for the circuit and appeal to them. There's no way to go to the appeals court. The only way it could happen is if Judge Boyce were to change his mind and allow the cameras. I suppose that's possible, because one of the rationales behind not allowing cameras in Lori's case is not to further pollute the jury pool for Chad's case. So I would suppose that that he could change his mind because there wouldn't be the same concern. So, hi, Edie Ruth. What happens in a pre-sentence investigation? This is a new term to this seasoned juror. Good question. It's not something that comes up during trial because it is a post-trial action. So generally what happens is there is a pre-sentence investigation report that is completed, and it covers a variety of things. you can think of it sort of as a shortened version of a mitigation phase. So what the investigator is asked to do is to look at the person's criminal history, which of course Lori has none, to look at her social structure, her family structure, her mental health issues, her all of those things, which would have been looked at in a mitigation phase, deeply in depth, sometimes 3 generations back. A pre-sentence investigation is nowhere near that in depth, but it does look at the same sorts of things to give the judge an idea of whether or not there may be mitigating circumstances. And that is the purpose of the pre-sentence investigation. Once that is completed, it is provided to both sides and the judge, and then the judge can take it into consideration, or the judge can completely disregard it. It is absolutely up to the judge and his discretion to decide what to do with that pre-sentence investigation. So, Metochrome, will we find out who has immunity? Very likely. Very, very likely. We know Zulema has immunity, although we don't know why. I have speculated that there have been several things that have happened in this case that have led me to believe that there are other people who have immunity, specifically Melanie Boudreau-Pulowski and Melanie Gibb. So, yes, I do believe that the defense will be asking them about these immunity agreements because it goes to their credibility. It goes to their motive to lie. If you have if you have an immunity agreement, you are going to want to please the prosecutor and toe the line to keep that immunity agreement, so you yourself don't end up going to prison. So we know that there has to be something that is incriminating as it relates to Zulema, because she already has an immunity agreement we know about. We know that because it came up in a recorded conversation that was held in Chandler, I want to say, I think that's right. Rob Wood went to Arizona, and it was either Gilbert or Chandler, where he had a meeting with both Zulema and Summer Shiflett, who is Lori's youngest sister, and that in the conversation that was recorded, it came out that Zulema has an immunity agreement. So yeah, I think we will find out who has immunity and why. And I think that will be enlightening and interesting. Flashback. Could John Pryor successfully argue that since the death penalty has been dropped in the case of Chad's co-defendant, it should be dropped in his case as well? I think that's a hard argument, because the reason why the death penalty was dropped was it was a penalty for the late discovery. The judge gave out a penalty for that same late discovery, but in Chad's case, because he had waived his right to a speedy trial, the penalty was that he severed the trials and let Chad set his case way out, gave him more time to get ready. In Lori's case, because she had not waived her speedy trial, the judge didn't have that option. So instead, he punished the prosecution by saying you can't have the death penalty. So I don't think that John Pryor really has an argument that because the death penalty was dropped as to Lori, it should be dropped as to Chad. But I do think that there is a chance that Chad could take a plea in return for dropping the death penalty. It's not unusual for co-defendants in a case where you have one going to trial before the other. It's not unusual for the second co-defendant to get a look at all the evidence and to get a look at the way the trial comes together and think to himself, maybe I should take a plea. So I think that there's at least a 50-50 chance that Chad may take a plea. And that may, in fact, be why they haven't reset a date in his case yet. So we'll have to wait and see. I don't think we're going to know much more about Chad's date until after Lori. Thank you, Bo Peep. Thanks for putting this out. We have 738 people in chat and only 384 thumbs up. Please go out and pop out and hit that like button. It makes a huge difference for us in the way that Twitter pushes content out. And we would love to be much higher up in the Twitter algorithm. So please do that if you can. As I said, I am going to be on with Harvard lawyer Lee again on Monday afternoon or Monday evening to talk about the case and about the opening statements. So we'll be getting those links out as soon as we have them. KCL, how will we find out who has immunity? Will the judge announce it or the prosecutor? How does that work? Well, the defense is going to ask them about it because they're going to use it as a way to say, you have a reason not to be truthful because you do not want to jeopardize your immunity agreement by saying something different now than you told the prosecutor back then. So usually it is the defense, and they are using it to say, just as they would a jailhouse snitch. In the case of a jailhouse snitch, you would say to them, well, isn't it true that you made a deal to get off lighter on your own charges for giving information in this case? Well, doesn't that give you a reason to make up information to please the prosecutor? Well, yeah. So I think that's the way we'll find out, is the defense will bring it up. Hi, she will. I really want to know who Audrey is. She had the highest trustworthy score from Chad. Now, there may be somebody out there who has a much clearer read on Audrey. My understanding and my recollection is that Audrey was a person who was in Missouri and was one of the people who Chad said was going to create the new Zion. So for those of you not familiar with the LDS Church, whether it is an offshoot or whether it is the mainstream church, the church believes that the end times that were predicted in the book of Revelations are upon us, hence the latter-day saints in their name. There's lots of discussion about when is soon, but most LDS members will tell you that they believe that the second coming of Jesus and the tribulations that are all foretold in the book of Revelations are imminent. And they believe that the tribulation will come, and the way that people respond to the tribulation will help decide who will be saved or who will be in the celestial kingdom. They believe that the new Zion, where Jesus will come and rule for 1,000 years, it will be built in Missouri. And so they believe that Missouri is the original site of the Garden of Eden. And they believe that the new Jerusalem, the new Zion, they call it both things, will be built. The city of light, the city on the hill, the new Jerusalem will be built in Missouri. And so one of the things that Chad was advocating for was that there would be, and this Julie Rowe as well, that there would be safe houses and safe encampments for people who were traveling from all over the country, all over the world perhaps, to convene on the new Jerusalem to get to Missouri and then to build city of the New Jerusalem, because the 144,000 were going to come from all over the country, maybe all over the world, and they were going to converge on Missouri, and there they were going to build the city of New Jerusalem. Once the city was built, then Jesus would come down out of heaven, and he would rule over that city. So, what I know so far is that Audrey is someone who was in Missouri that Lori visited with, and that she somehow was involved with the organization. Right, right. Okay, so KCL's got it. Audrey Baratario, I think, Baratario, Independence, Missouri. Lori called her on the way to Walgreens to buy the flip-flops after Charles was murdered. And Lori visited the place of the second coming of Jesus with her in Missouri. Right. There are a couple of sites that are believed to be the original site of the Garden of Eden, and then the site where the New Jerusalem will be built. So that's why she was light. Audrey was also in Chad's phone, and according to Sean Littlebear, Chad had regular communication with her also. Wow, KCL, you have been on top of this. I think that's right. I also think that she was, if you recall, there was a group, Eric Smith and several other people, including Julie Rowe, who were meeting regularly to discuss these new interesting doctrines, including multiple probations, polygamy, all of those things. And I think that Audrey was in some way involved in those discussions as well. So she definitely was someone who was a follower of Chad's beliefs. Polio. Question: during Lori's trial, how will they handle Chad's involvement? Could Chad have a statement, witness, or question mark? Here's the problem for Chad. Lori can't call Chad as a witness because he has a Fifth Amendment right to remain silent. And if he's smart, he will continue to exercise it. So he can't be called as a witness. Now, lots of people have asked about the marital privilege. It doesn't exist in this case. Yes, they are legally married. However, there is an exception to the Idaho law that says that you can't claim the marital privilege if the case has something to do with either of the parties' abuse or neglect of either of the parties' children, which obviously it does. So they don't have marital privilege, but Chad certainly could and should and will claim the protection under the Fifth Amendment. So Chad's involvement will have to come in through the testimony of other witnesses. You overcome the hearsay objections because they are parties or party opponents, as they are called. And so the statement of a party comes in even if it's hearsay. So one thing Saul M., I'm going to answer this question in a tiny second. But one thing I did want to point out is that in this case, it is very unlikely that they are going to bring up anything having to do with Charles's murder in Arizona. The reason for that is because of Evidence Rule 403B. We heard about this a bit in the Murdoch case. And in the Murdoch case, the judge ruled to allow in 403B evidence, the evidence of Alec Murdoch's prior bad acts, because they related directly to the motive for the murder. But in this case, I doubt anything having to do with Charles is going to come in as a proof of a former bad act. Okay, Saul, how does Alema and Melanie G have some kind of immunity if their stories are always changing? Well, I think this happens in just about any witness's statement. Memories fade, recollections bubble back up, and memory is a very strange animal. Memory is not linear. It is not. It's very relational. It's. I think of one thing, and that reminds me of something else. It is not a real linear point A to point B process. So it could be that those are some issues. It could also be that they're changing their stories. I don't know. That is something that is going to be up to the jury as the finder of fact to decide whether or not these folks are telling the truth now or they were telling the truth back then. But it's clear that they could still be offered immunity from prosecution in return for their testimony. Now, it could be that the defense, they're going to open a door a bus could drive through, or a jail bus, by changing their stories. Interestingly, as we were talking about the you can go ahead and put that question up, but I did want to just say, kind of as a aside, a gee whiz about the physical layout. The courthouse in Boise faces the street. Right next to it is a parking lot and then a parking garage. And the way that Lori is brought to court is that she comes on a big white inmate bus. And she comes with all the other inmates who might have court that day. It's not just Lori on this big bus, but it's a big bus, like a Greyhound bus. And they pull it in. It pulls in, goes around the courthouse, down a ramp, and it goes into the courthouse Sally Port. The media has not been allowed to photograph Lori going in and out of the courthouse the way they did the perp walk with Alec Murdaugh. The media has not been able to catch even a glimpse of Lori coming in and out of the courthouse or even in and out of the courtroom. The inmates are housed in the basement, and there is a huge Sally Port for them that entire bus fits in. So a big roll-up door comes up, and the bus pulls into this garage. The big roll-up door comes down and is secured, and then the inmates are allowed out of the bus. In Lori's case, the 400, the fourth floor and the 400 courtroom does not have individual inmate holding cells. So she is brought up and down from the basement up to the courtroom and back as needed. That may add a little bit of extra time to breaks if she needs a break to go to the restroom, or she's got to go all the way back down to the basement. Okay, Brennan Tube. Y'all are probably tired of me asking this, but I really want to know. Why do attorneys want the jury polled after a verdict? Has there ever been a juror that says, no, that isn't their verdict? You know, I have never heard of one. It is a formality, and I think that it is, and I never get tired of answering questions. It is a formality. There are things within our criminal justice system that are very formalized and formulaic. And so the order that we take a trial, who goes when, who gets the first peremptory challenges, which side goes first, how many, how the fact that the prosecution gets a rebuttal, all of those things are part of our historical process, and polling the jury is one of those things. In a state where the jury has to be unanimous, it seems a little silly. But in other states where two-thirds of the jury is all that's required to decide, then certainly both sides are going to want the jury polled to make sure that they have the right number of conviction votes. So hopefully that makes sense. Part of it is just tradition, and part of it is to make sure in those cases that they do have all the votes that they need in order for a conviction, in cases where they don't have unanimous juries. Hi, Jane. Question. I would like to try for a ticket, but hesitate to take a spot that media or authors need. It feels, since no taxpayers attend for the most part, maybe they help with court accountability. Well, I agree completely. And I don't think that you should hesitate for a second to try and get a ticket. At a minimum, you may be able to get a ticket in the overflow room. So let me just fill you in on how that's working right now. What's happening is you go in at 8 o'clock and you press the button, you put in all your information, you press the button, you say, yes, I want to go. You have to hit the little time bar. You say, I want a ticket, and you will get an email back confirming that your request has been received. Then the next thing that's going to happen is that the clerk of the court is going to go through that list and make sure there are no duplicates, because people were putting in for more than one ticket. They're weeding all those out. And if you're caught putting in 2 requests, you're disqualified from that day. So what happens is, after those 60 seats in the courtroom fill, then at noon, the overflow viewing area, the tickets to the overflow viewing area open. So there's a good chance that if you don't make it into the courtroom, that you will make it into the overflow viewing. And the overflow viewing is quite an interesting place to see the case. Remember that in the case of the people who are sitting in the gallery, we're looking at the back of heads. So sometimes it is better to be able to see the live feed. Now, I will say that I think in part because of all the complaints early on about the camera being trained on Lori all the time, the cameras are back a ways. It is a little difficult to see her facial expressions. It's very difficult to see sometimes even her mannerisms and what she's doing. It's difficult to see. People have asked me, does she have on makeup? I don't know, because I can't see from the viewing room. I hope I'll have a better answer on Monday when I'm in the courtroom. In the past, when she was in Fremont County, she was allowed access to makeup. I have been told by folks who know in Ada County that is not an option, so it's unlikely that she's wearing makeup at this point. I would encourage you to go ahead and put in for it, Jane, and see what happens. I don't think you should be worried about taking a spot that the media may need. I think the media has been pretty diligent about getting their requests in right away and right at 8 o'clock. And so I wouldn't worry about that. You have as much right to be there as anybody else. And even if you don't make it in, then the overflow courtroom is an interesting place to be. It's more relaxed because you can come and go as you want. You're not disrupting court by coming in and leaving. If you get a seat in the regular courtroom, you can only leave during breaks in court. You cannot come and go in and out of the courtroom except during the break times. So I will make sure that I post in the description the link to the reservation system, because I want to make sure that y'all have it if you decide that you want to try and get in. Do understand, though, those tickets went in the first 2 minutes, um, of Friday morning. So 60 seats went in the first 2 minutes. Um, so you really have to be sitting in front of your computer, logged in, and preparing to refresh your screen and to keep hitting the button until you get in. Bo Peep, do you think Lori finally realizes how much evidence the prosecution will be bringing up? Nope, I don't. I think that she still absolutely believes that she is going to be exonerated. I absolutely believe that she believes that this is merely a trial that God has sent her way and that he will ultimately deliver her from it. I do not believe that she has taken responsibility for what happened, has internalized her role in it, or any of those other things. I think she still absolutely fundamentally believes that what she did was right. Does that make her insane? It does not. She was able to understand that what she was doing was wrong by social standards. She believed that she was justified in doing it, but she knew it was wrong. And that is evidenced by all the great lengths she went to cover up what they've done. Left undone. Thanks, the good Lori. Appreciate your coverage. Hi, Kathy. I'll be there at some point. Look forward to saying hello. I look forward to seeing you there. I know that there have been a couple folks who've been in the overflow room who've been feeding information to you for your channel. And so I'll look forward to seeing you there when you arrive. Lee here. How long is it going to be to get the day's audio out to the public? Well, this is a good question. And I want to remind you, I have to say, I think Ada County has been doing a bang up job at managing this trial. I think they've done a great job of managing 1,800 jury subpoenas and jury questionnaires. And I mean, it's just been on a scale that's unprecedented. And I think they have done a really good job. This is an issue that really kind of falls at Judge Boyce's feet. I think he has to release the day's audio before the court can produce it for the people who request it. What we were told early on when we had a kind of a Zoom meeting with the court, the media did, was that the day's audio would be available on a thumb drive sometime later in the day. Now, the judge has said that he is going to run court from 8:30 to 3:30. And I think one of the reasons he is stopping at 3:30 is to give court staff enough time to get those recordings out before 5 o'clock. So I expect that once they really get into the routine of this, you're going to see the audio of the day's events download sometime probably between 5 and 6. Nate Eaton at East Idaho News has said East Idaho News is going to be obtaining those, posting them both to their website and their YouTube channel every day. So there have been a few little glitches and a few little hiccups as they've gotten started. And the fact that it happened during jury selection probably was the best thing because they were able to work some of the kinks out. One of those things was that initially the judge had communicated to the court that any time that they that they were going to be questioning individual jurors, and that some of those questions were going to be questions that shouldn't be transmitted to the public. So the court interpreted that as any time that they were asking one-on-one questions of a juror, the sound should be cut off. That really wasn't the case. And when the media questioned it, then the court sort of revised their procedure. But what it meant was the first day, the court said they would provide a written transcript of all of those sessions, because many of those sessions had to do with whether or not the juror had seen publicity and whether or not they formed an opinion about the case based on all of the publicity. And there wasn't really any reason the media couldn't see that. The reason for asking those questions individually was so that the information one juror had didn't get transmitted to the whole group of 15 that were being questioned. So, I mean, we didn't want one person saying, oh yeah, well, I saw the dateline and I know this and I know that and I know the kids were found in the backyard and I know all this information, and then have it be, well, juror number 2, how did you learn that information? Well, I learned it from sitting here and listening to juror number 1. So that was the reason for not making those, asking those kind of questions in the group. So day 2 rolled around and then they had it dialed in a little bit more. So the only time they were cutting out the audio was when they actually had questions of a personal nature that they were asking jurors. So that made the audio recording more complete. As it stands right now, I think you probably will see them hit East Idaho News website and YouTube somewhere between 5 and 6 Mountain Time. So that would be 4 or 5 Pacific, and you guys can do the math from there. Hi, Tara. What do I think Lori's attorneys say to each other about defending Lori behind closed doors? Well, I'm here to tell you, first of all, lawyers are some of the worst gossips in the world. So among themselves, they are horrible gossips. And I am certain that they've had many conversations about the difficulty Lori presents in terms of presenting a defense. I think they talk to one another about how to get around some of the difficulty that she presents. But remember, she has said she does not want to present a mental health defense. She does not want to have her mental health brought up at the trial. And I think that they are in many ways frustrated because they're operating with one hand tied behind their backs. And I'm sure they talk very frankly about that with one another. They're both very experienced attorneys, and I suspect that they've worked together before and have a good relationship with one another, and that it may be a lot of commiseration over having a client that it is difficult to guide. Attorneys often talk about client control and whether or not they're able to advise a client in a way that helps them protect their client's rights. And in this case, I think they have no client control over Lori. Hi, Jennifer. You mentioned previously that it was possible, if Lori is convicted, that she might be granted a new trial on appeal. If that happened, could they reintroduce the death penalty? I don't believe so. Remember that the retrial would have to be under the same circumstances and for the same charges. Excuse me, I just bit my lip for some reason. The retrial would have to be for the same charges as the original conviction. And that would mean that she was not facing the death penalty the first time, and that would not be reinstated for a new trial. Good question, though. Y'all are thinking about these little legal ins and outs. Denicia Rose. I'm worried the prosecutors are convinced it's a slam dunk and Lori could be the next Casey Anthony. Would Arizona immediately arrest her in a worst case scenario? So there's two parts to that question. So I'll start out with worried the prosecutors are convinced it's a slam dunk. I think that if the prosecutors were worried that it was a slam dunk, that they had a little bit of a sobering comeuppance when the judge took the death penalty off the table. I think that they were surprised and sobered by the fact that the judge sided with the defense and said, prosecution, you have done this one too many times, and now that we are so close to the trial, I have to call you out on it. So I think that if they at one point felt it was a slam dunk, I think they don't as much anymore. I think they're a little nervous, frankly. Um, I don't think that Lori could be the next Casey Anthony, and here's the reason why. Casey Anthony was charged with one count of murder. There were no other options. There wasn't second-degree murder. There wasn't negligent homicide. None of that was on the table. The jury was not instructed on it, and that was the only charge. So the jury was forced to say, do we believe beyond a reasonable doubt that Casey Anthony killed her child and that it was premeditated, knowingly? That was the only question they could answer. They didn't have the ability to say, well, maybe it was an accident, or maybe it was, and give Lori sort of their Casey sort of the benefit of those lesser included offenses, because they didn't exist. In this case, the prosecutors are they've got many different charges that they can work with, and many different victims. And so charges as to one victim may not be as applicable to the other victims. The other piece is that this is a case that relies heavily on conspiracy. So even if they say, we don't think we have enough evidence that Lori was directly involved in whatever physical mechanism ended her children's lives, but we're utterly convinced that she conspired with the people who did. And in that case, she's guilty. So I think this jury will have, sorry, of barking dogs, must be a late Amazon delivery. I think this jury has many more options than the Casey Anthony jury did. But in the case, in some alternate universe or in some stretch of the imagination, Lori were found not guilty on all the charges, Arizona would immediately arrest her, and she would immediately go to Arizona to face the conspiracy charges for Charles. And I think the conspiracy charges for Charles are pretty slam dunk. Tara, what was the mood in the overflow room this week? So excited for you to be in the courtroom on Monday. The mood in the overflow room was a little upbeat. A lot of people who know one another from having covered other cases, who were seeing people that they knew. There was a lot of, renewing acquaintances and chit chat. And it was pretty relaxed in there, because really they were dealing with jury selection. So we were listening to groups of 15 people come in, and the judge and the defense and the prosecution first, then the defense, asking the same questions over and over, using the same examples over and over. People started losing interest and started, talking about other things. There was a lot of discussion about who was getting into the courtroom on Monday, what the reservation system was like, the navigation of the reservation system. And in general, it was a fairly upbeat, relaxed environment. That absolutely will not be the case on Monday. On Monday, I guarantee that it will be a much more serious, professional, somber kind of an atmosphere. Um, Primarily because they're going to be live in the court. They're going to be hearing and seeing some sobering information, and I expect that it will be much more of a respectful, more somber mood than it was in the overflow room. And I would expect that the overflow room will continue to be a little bit less formal, a little bit more relaxed, and uh, in the overflow room, people can come and go. In the courtroom, you can only come and go at the break. So I think it'll be a different environment, but I think it will be overall more serious and somber on Monday. Good question, though. Thank you so much, Kathy, for the super sticker. I don't know whether you're a frequent visitor or not, but all of our super chat donations go directly to our moderators. And I appreciate that you all are generous, so I can be generous with them. So thanks for the donation. Diabolical 58. Wow, that's an interesting screen name. Have you read any of Chad's books in your research in this case? Oh, my friend. So I spent the whole summer while I was waiting for this case reading, and I read, at one point I had them all stacked up on a desk and took a picture of them. I read Mainstream LDS Doctrine. I reread for the third or fourth time Under the Banner of Heaven. I read Julie Rowe's books, Melanie Gibbs' books, Denver Snuffer. I read John Pontius. I read Eric Smith. I mean, I read everything from mainstream Joseph Smith history, history of the church, and I did read both of Chad's autobiographies and the first one of his fiction books. Now, I know that before I'm finished with this book, I need to read the rest of Chad's books. However, every time I sit down and think about doing that, it kind of just sticks right here. So, because I got to be honest, they're bad. They're very juvenile. They're very poorly written. They read kind of like an eighth grader's short story project for English. So I know I'm going to have to bite the bullet and do it, but not yet. Not until after the trial's over. Tara Wells, last question. I hope it's not the last question, but we are about 10 minutes out from being done. We have 857 people in chat. Thank you so much for spending your Saturday with us. And Tara's question is, how was the pizza party? It was the bomb. It worked out great. Thank you to Julie Reichart, who set it all up. We had a little room and we all got together. We had some pizza, we had some beers and some soft drinks, and we got together and visited. I would say at one point there were probably 25 people there. Gigi came in and was able to meet some of the folks that I've gotten to know here in Boise and who also follow her. So we just had a blast. It was great getting to know all of our listeners who were there, and I appreciated so much them taking the time to come out and shake hands and give hugs and get the chance to put some faces to screen names. And I wish you all could have been there because it was great fun. Brenna, which are worse, Chad's books or Melanie Gibbs' books? She had awful spelling and grammar errors. Well, I don't think any of them can spell or punctuate to save themselves or get out of a brown paper bag. None of them had ever heard of Grammarly, that's for sure. Chad's books are so much more juvenile. They're definitely um, more like the eighth grade kid writing a short story. They're very narrative. They're very kind of phantasmic. A lot of telling and not showing. Very typical, very sophomoric kind of writing style. Melanie Gibb, on the other hand, is so preachy. I mean, I know it's supposed to be a book about her faith journey, but it is really to the point of um, yeah, I'm better than you, and you're never going to be as good as the people who have achieved this level of spirituality. So, yeah, it's not as Chad's books are very juvenile. So, my husband just decided to turn the TV on. And so if you hear that in the background, it's because he's watching TV. Um, he must be giving me the clue that it's time to wrap up. The website for Melody's book was turned into a porn site by hackers. I heard that. I heard that hackers had taken over her site, and it was now a site for uh, adult material. Yeah. Graya? How will they choose the 12 jurors out of the 18 that will decide guilt or innocence? According to what Judge Boyce told us at, as the jury was being selected, the 18 jurors will all hear the evidence, and it will not be until the close of evidence that they will draw lots. They'll just draw numbers out of a hat and decide which 12 jurors will actually deliberate. And the purpose for that is to make sure that all 18 jurors are paying attention and could potentially deliberate and decide the case. That's an excellent question. I think you meant loin fire. Loin fire. Yeah. That's gonna be interesting when that whole text string comes out, because it's very damaging. It's very incriminating, talking about those things. So I agree. Loin fire is going to be interesting when it finally comes out in public. I think there's nothing funnier than hearing Keith Morrison from Dateline in his gravelly TV voice say, loin fire. At one point, there were some folks who had downloaded that and made it their telephone ringtone. So every time their phone went off, Keith Morrison said, loin fire. Lori, do you sense that Lori Vallow is different this time around in court? No, I don't think she's any different than she's been all along. She's not more earnest. She is not more less bubbly I mean, her lawyers certainly have been advising her how to behave in court, and maybe she's taking that into account or taking that to heart. But I don't believe that she is any different than she's been at any of the previous hearings that I've sat in on. So that's a good question, but no, I don't think she's any different. Think she honestly believes that she is in the right, that she is doing that her selection is a gift from God, and that she is one of the elect, and that this is merely a test, and that God is going to deliver her from this. I mean, I think that there is certainly an of element of feeling like her followers can control the elements, and that somebody is going to call up an earthquake that is going to usher in the tribulation, and it is going to be like the New Testament. The walls of the prison are going to fall down like they did for the Apostle Paul, and she's going to walk free. I just think that she is so deeply steeped in this religious belief, that that's where she's at. And, it is always a question, when does fervent religious belief tip over into a diagnosable religious delusion? It's a really fine line, and she's walking it every day. Hi, uh, Kara J. Did I read Colby's book? I did. And the interesting thing about Colby's book is that it stops before this. His intention is that that is the first volume, and it actually stops with Charles Vallow's death. I think it's been a while since I read it, but my recollection is that it ends with Charles's death, and it will apparently this second volume will pick up with the children's disappearance, but he may be waiting until the trial is over to be able to write that second volume. Again, is it the most artfully written book? No, it's not. But it's very heartfelt. And again, Colby is talking about how his spiritual relationship with God has led him through so many of the trials in his life. Hi, Rebe. Sorry, a bit late, so may have answered already. Could the defense sequester him after his initial testimony just to keep him out of trial? I think you're talking about Larry Woodcock. So I want to be clear that there are some folks who have attributed to these defense attorneys some ill intentions, I guess I'd say. And I don't believe that's true. And it's not just because I'm a defense attorney. I've been watching these two guys since they came on the case. Now, if we were talking about Mark Means, I could see Mark Means doing things that he thought in the name of strategy that were also hurtful or hateful. But I do not get the impression that either Jim Archibald or John Thomas are the kinds of humans who would do things that are hurtful or spiteful only for the purpose of hurting people. And I don't believe that they would willingly participate in that if Lori wanted them to do that. So I want to be clear, and anybody who listened to Scott Reich, who broke down the statutes until you wanted to claw your eyes out. I love Scott, but he does kind of get a little pedantic when it comes to the statutes. So he went through the statutes, and it's very clear that those statutes are not well written, that they are not, it's very difficult to sort of parse them and understand what the legislature intended when they wrote the statutes. It's just a poorly written law. The problem with that is just Judge Boyce was forced to interpret a poorly written law. I think he did as well as he could with bad law. So I don't believe that either Jim Archibald or John Thomas is going to demand somehow that Larry Woodcock be sequestered and kept out of the trial after his testimony, arguing that they might call him again. I think it's highly unlikely they would ever call Larry Woodcock. He has nothing to offer the defense that can't be brought out on cross-examination. And there's absolutely no reason for them to do that. Additionally, if they're going to call him as a rebuttal witness, the rebuttal will only be to things he's already testified to. You can't call a rebuttal witness to testify to something that hasn't come up in court, to new information. So it wouldn't make any sense in either of those cases for him to continue to be outside the courtroom. I do not believe, I believe that once Larry has testified, he will be able to come into the courtroom and stay. He is allowed in for opening statements, and I hope that the prosecution will take him sort of out of order and get him on the stand as soon as they can. This is one of the reasons why it's important for opening statements to give that roadmap, because they'll be able to say, Larry Woodcock's testimony, the story starts here. Larry's testimony comes in here in the timeline, in the storyline. But we're bringing him in early and we're putting that piece in. A criminal case is like a puzzle, like a jigsaw puzzle. And you go around and you start by finding the edges and all the straight pieces, and you kind of find the pieces that are easiest to put in first, and then you build from the outside into the center. Now, like a jigsaw puzzle, often you can tell what the picture is, even if there are a few pieces missing. And that is always a good analogy when defense attorneys are talking about reasonable doubt. So if you have this jigsaw puzzle and it's a 500-piece puzzle and you're missing 3 pieces, but you can still tell what the picture is, that's beyond a reasonable doubt. However, if you're missing a lot of pieces and you can't tell if this over here is a rose or a dog, then that's reasonable doubt. So it is another description of how you put a trial together. So I don't believe that Jim Archibald and John Thomas, I don't think it's fair to attribute bad motives to them or evil intent. I think they're doing a very difficult job, and they're going to navigate this very difficult job with a client they can't control as well as they possibly can, because ultimately their job is to protect her rights and to make sure that if the state brings a case, they can prove it. It means putting the evidence to the test. And when we do that as defense attorneys, we become the backstop for every citizen out there. Because, oh, sorry about that. I say, Mr. Prosecutor, please show me your proof. And if you can't show me your proof, then go away until you can show me your proof. I'm the one who says that provides the check and balance for government power. And that protects not only the guilty, but all the rest of us. So with that, I am going to thank everyone for being so kind to spend your Saturday night, not only your Saturday night, but the Saturday before Easter with me and with us. I want to thank you all for continuing to support us. Thanks for 844 people in the chat. Thanks for all of your participation and your generous donations for our mods. Thanks for all of you who bought me a cup of coffee. Believe me, I'm going to be fully caffeinated when it comes time for court to start next week. And I want to say thank you very much to all of you who continue to support. Look for our shorts. Hopefully you've subscribed so you get notifications when we go live on those shorts. Thanks so much from our mods and from all of us here. Don't forget, I'll be on with Harvard lawyer Lee on Monday. We'll put that link out for you. And I will be back to give you a rundown on what's happening next week. Thanks once again for joining us. Have a good night. Have a very happy Easter. And for all of those folks, and happy Passover if you happen to be celebrating that as well. I will just close by saying, he is risen indeed. Good night.